Hey, buddy. Welcome to I think the 8th video in my Mounk Tounk series. This is going to be the first one where we cover an admission of the state that they were wrong about something and that they misrepresented something, both during the trial and during Antonio's revocation hearing. So we're going to start here. This is the state's petition to revoke Antonio's probation. We don't need to go through this in detail, mostly because it's all wrong. But one important thing is they will mention that the plea agreement, the operative plea agreement, is attached to Exhibit B, and we're going to take a look at that in just a second. But they reference Exhibit B a bunch here and here. And so they're very clearly saying that Antonio's, the effective plea agreement, is Exhibit B to this document. And we'll scroll down to that real quick. Why are you not working? That's frustrating. There we go. So Exhibit B, that is this written document. And you'll see here it's labeled 1AS. It was referred to that way during the YSL trial. 1AS or 444 Yankee, it's the same thing. What you'll notice is that it is in writing. It is not in oral agreement. There are other clues in this document that prove that this isn't the correct plea agreement, but all we need to know is that it is in writing. So I'm going to now show you this excerpt from the state's opposition brief to the appeal that we filed on behalf of Antonio. They admit what I'm about to say a few times, but this is just the simplest example. And this is the state writing. When the written plea agreement, referring to what I just showed you, was signed by both parties, the agreement proposed that sentencing on count 30 be withheld until appellant testified at the trial. That's true. This was offered so that if appellant completed the terms of his probation, no sentence would be imposed. That doesn't make sense. That's just gibberish. What he's trying to say is this was offered so that if appellant successfully testified at trial and told the lies that they wanted him to tell, that no sentence would be imposed on count 30, because Antonio could withdraw his guilty plea, and then the state could null pos the charge. That's what they're trying to say instead of what they did say. Next sentence. At the guilty plea hearing, appellant acknowledged that he understood the recommended plea offer, which reflected the written agreement. That's 20% true. That doesn't get into which plea agreement was the right one, but okay. When the trial court brought up that the aim for appellant to be released that day could not occur under the terms of the plea agreement, the parties renegotiated a new plea agreement. The parties renegotiated a new plea agreement, so not the written plea agreement, which changed count 30 to a plea to 15 years probation. That also doesn't make sense, but whatever. The state further added that it would not object to suspending the probated sentence on count 30. Okay, so this is a great example of the sentence right here. Between the written plea agreement and the subsequent oral plea agreement that was accepted by the trial court. Between the written plea agreement, which is this right here, Exhibit B, and the subsequent oral agreement, the actual agreement that was accepted by the trial court. So they're admitting that this plea agreement, 1AS, is not the operative, correct, final plea agreement. So everything that was said at the trial during Antonio's testimony about his plea agreement, every single thing that the state said during his probation revocation hearing was false. They were completely wrong. Antonio was completely right. Antonio was telling the truth, and the state was lying. The state has admitted this. It's not in dispute. The state acknowledges that they were not telling the truth. Antonio was telling the truth. Conclusively proven. The state admits this. That's all you really need to know, but I'll show you this excerpt from Antonio's guilty plea hearing, which reflects what I just said. I should say that I'm going to be quoting Miss Love here, but I actually don't really have a problem with anything she says here. I don't think there's anything wrong with what she said here. But she starts off, this is just her describing the terms of the written plea agreement. The court asks, the issue is that the parties wanted Antonio to get released immediately after the plea agreement, but the way the written plea agreement is termed, the terms of it, he would have to stay in Rice Street because there would still be a charge that was unaccounted for. So Judge Glanville correctly is asking, so how do we get him out? Because we're withholding a sentence on count 30. So what are we doing? The court says the issue is going to be he's got no sentence under that particular count 30. So I'm either going to have to give him bond. I can wait to sentence him on count 30, pursuant to his negotiated plea, but he won't get released unless he has a bond. Which is true. Let's see here. Bond still in effect. Mr. Chamberlain, who's Glanville's assistant, says, as of right now, there's no bond set. Love says the state has no objection to the court granting a signature bond to her credit. No, I actually do have a problem with this, but not a big deal. It's not really her fault. She's a little... I think she's generally mistaken on the law on this point, but not a big deal. Mr. Chamberlain, for the clerk's office, we have to fashion it this way. We can only do count 1 and then count 30 as a bond. That is the only way he's going to be released. And then Chamberlain describes the issue some more. Frankly, this is also grounds for appeal. I thought there was a better ground, so I didn't go into this, but this technically is probably improper judicial participation in the plea discussion. But here we go. This is Judge Glanville's, this is the critical thing. The court. You have one of a couple options. You just can't do it this way. So that is Judge Glanville rejecting the written plea agreement. So I don't really have any problem with any of that. I don't think there's anything unethical there or anything strange. It was just a kind of an oversight in drafting from the parties. But then years later, when Antonio was called to testify, and they asked him about the written plea agreement, that's where the issue is, because of this right here. You just can't do it this way. That is not the right plea agreement that was brought up at trial. And anyway, so they go off record for a little bit. And then Love and Wright discuss the terms. They come to a new plea agreement. There is an issue. There's several issues with that. I think they're oversights, though. I really don't even have that much of a problem with anything that anybody did here. In terms of ethics, I think they just made some mistakes. And as you guys know, I have no problem accusing people of misconduct. But I think this case is mostly just an oversight. Or this specific instance is just an oversight. But yeah, so that is the problem, is Judge Glanville rejected the plea agreement, and then the parties negotiated a new plea agreement, which is totally fine. Again, the issue is that the state then used the original plea agreement to get Antonio into trouble, even though, as they well knew, that was not the right version of the plea agreement. And again, that's not me saying this. That is the state saying that in their appellate briefing. I guess I can just show you that I'm not lying. This is the state of Georgia's appellate brief. I think it's written by Bernick, Alofani, and Kevin Armstrong also had their names on this. But yeah, this is their brief. That is their words. So yeah, not in dispute that Antonio Sledge was right and the state was wrong about the plea agreement.